popular mechanism for poverty alleviation, especially for developing countries around the world. This microfinance service adheres to the principles of Islam as a form of social responsibility. Yona Islamic Microfinance is the Islamic microfinance of choice in the Gambia, trustworthy and reliable. At Yona Islamic Microfinance, we provide savings products, current accounts, financing products in conformity with Islam. In addition, Yona Islamic Microfinance also offers local and international remittances, takaful fund, management of zakat, management of awqaf, trading and investment, and building of strategic partnerships to bring financial services to the doorstep of the poor with donor projects, madrasas, youth organizations, women groups, and farmer organizations. Make a choice with Yona Islamic Microfinance today. For more information on Yona Islamic Microfinance, call 377-2151 or 9832-151 or visit Yona head office at Tipa Garage, Bakote, or visit any Yona branch located countrywide near you.
Appointed the offices of rulers and parliament for the welfare of society and just government of men. We beseech thee to behold with thy abundant favor us thy servant whom thou hast been pleased to call to the performance of important tasks in this land. Let thy blessing descend upon us here in this house assembled. Grant us that we may treat and consider all matters that shall come under our deliberation in so just and faithful a manner. Promote thy honor and glory to advance the peace, prosperity, and welfare of this country and of those whose interests thou hast committed to our church. Amen. Kerr.
Correction and approval of record of votes and proceedings of the National Assembly sitting of Wednesday, 14th June 2023.
Honorable Minority Leader, order. Honorable members, the record of votes and proceedings of the National Assembly sitting of Wednesday, 14 June 2023 is before us for correction and approval. Can any honorable member please move that the said record of votes and proceedings be considered and approved? Member for Panyomi.
Thank you very much, Honorable Speaker, for giving me the opportunity. I rise to move a motion that the record of votes and proceedings of the National Assembly sittings of Wednesday, 14th of June, 2023 be considered for correction and approval. Thank you.
Any seconder? Member for Sami.
Thank you very much. I rise to second the motion.
It has been moved and seconded that the record of votes and proceedings of the National Assembly sitting of Wednesday, 14 June 2023 be approved. Any correction or observation from honorable members? We will look at the records and votes beginning with page 1. Any issue or issues or observation on page 1? Page 1. Can we move to page 2 now? Page 2. Page 3. Page 4. Member for Woolleys.
Page 4, yes. Okay. Thank you very much, Honorable Speaker. If you go to the first paragraph, this page has a lot of problems. The first paragraph, where it says the Honorable Speaker should be invoked, be in the past tense. And in the last line of that paragraph is international cooperation and Gambians abroad. You've seen that? To answer, instead of answer, to answer. The toe is missing. To answer oral questions under his purview. That's how it should be. What they have there is cooperation and Gambians abroad answered his oral questions. You've seen it.
Honorable members, on top of page 4, the first paragraph, Honorable Speaker invoke. It should be invoke, ED.
Yeah.
And on the last line, Gambians, instead of Gambian, it should be Gambians abroad, plural. And also to answer, instead of answered his oral question, to answer his oral questions. Mic, please use your mic, Honorable. Use your mic.
If you also go to question number 192, the same problem, Bintang Karan Nai. What is there is Karania. And if you go to number 4, the last paragraph, number 4, is Honorable Transport. It should be Honorable Minister for Transport, Works and Infrastructure. You've seen them.
On 192, Fonye Bintang Karanai. Yes. Have you seen it, honorable members? It's Karania. Thank you, honorable members.
The last paragraph, the minister is missing. Minister for Transport is missing. What they have there is Honorable Transport.
Yes. Have you seen it? The last line, Honorable Transport, Works and Infrastructure. Honorable Minister for is missing. Any other observation or correction on page 4? Member for Tumanna.
Thank you, Honorable Speaker. On the same page, number 3, the same thing is missing there, Honorable Defense. So supposed to be Honorable Minister for Defense. Yes.
On the same page, item 3, the following questions and number of supplementary questions were asked and answered by the Honorable Defense. It should be by the Honorable Minister of Defense. and wherever it appears. On page 5, can we now move to page 5? Member for Woolly is?
Similar problems there. But the first paragraph, the second line, which were answered, should be answered. The ED should be there.
Instead of S.
Instead of S. The same thing to the second line, the second paragraph, the last line. And if you go to question number 168.
I think it's the same. Is the same.
Yes, you will see it in
the whole page, if you look at it.
Yeah, but the 168 is a different one. Is disposed. It should be disposed of. Is the D should be there. It should be in the past tense. And then, of course, if you go to 5, the last paragraph is Honorable Minister again. Minister is missing. Minister for Environment. Of course, in addition to your observation that the answer is missing in some.
Yes, honorable members, you know what the honorable member Fully is raised on one, on which were answers, and it appears throughout the whole page of 5, and also on the 4th line, and question number 168 and 169. Instead of disposed, it should be disposed of. Any order? Yes.
Number 5, the last paragraph. Minister for Environment. Minister for is missing.
Yes, that's why I said earlier on wherever it occurs. In various different portfolios. Can we move to page 6 now? Page 6. Page 6. Page 7. Member of Woolly is?
Yes, just a little typo. There is question number 185. Supplementary, second line. Supplementary questions, which was. So it should be where, which were answered. But they are questions.
The honorable member for Woolly is proposing on question number 185, the last line, generated 2 supplementary questions, which was answered, and which were answered according to his proposal. Any more on page 7? That's all. Page 6. Yes, page 6. The same, the Minister of Youth and Sport, number 7. I said wherever it. Honorable members, it has been moved and seconded that the record of votes and proceeding of the National Assembly sitting of Wednesday, 14 June 2023 be approved with amendment. Those in favor, please say aye. Those not in favor, please say no. The ayes have it. Clerk.
Thank you. Bill, with reference to Standing Order 66, second reading of the Legal Practitioners Amendment Bill 2023 by the Honorable Attorney General and Minister for Justice.
Honorable members, you will recall that the first reading of the Legal Practitioners Amendment Bill 2023 was done on Monday, 5th June 2023, and today is appointed for the second reading in accordance with Standing Order 66-2. Therefore, pursuant to Order 67 of the Standing Orders, I now invite the Honorable Attorney General and Minister for Justice to move a motion for the second reading of the bill entitled Legal Practitioners Amendment Bill 2023. Honorable Minister.
Thank you, Honorable Speaker. Good morning, Honorable Members of the National Assembly. Honorable Speaker, the bill entitled Legal Practitioners Amendment Bill 2023, having been read the first time, I hereby move that the said bill read the second time. Honorable Speaker, the object and reasons of this bill is as follows. Currently, it is nearly impossible for the disciplinary committee to sit and hear complaints brought before it due to the composition of its membership. As a result, the committee is inundated with its statutory roles. Also, it is difficult for some members of the society to afford service of a legal practitioner because of their poor financial conditions. Again, the society has high hopes on legal practitioners to represent them in various capacities, and thus the profession needs to be well regulated for effective and careful service delivery. Therefore, this bill seeks to empower the Council, and Council here means the General Legal Council, to establish such panel of disciplinary committee which shall consist of a judge of the High Court, a state law officer of not below the rank of a principal state counsel, and a legal practitioner of at least 10 years of standing, as opposed to what currently exists. This would allow the flexibility in the sitting of the committee to immediately deal with issues brought before it. The bill also seeks to properly address the issues of professional misconduct of legal practitioners, and also pave way for legal education, legal aid, and pupillage. I move on those terms, Honorable Speaker.
Any seconder? Member for Opasalo.
Thank you very much, Honorable Speaker. I rise to second the motion and also to speak on the motion as well. We are presented with an amendment of a law that we've actually dealt with here. If you look at the Parent Act of 2016, normally when laws are made, they are meant to solve an issue, an anomaly in society. But also they are also meant to stand the test of time. But sometimes the test of time may not be too long. And if you look at the bill, when the act itself, the Parent Act, you are talking about almost 5-6 years ago when it was, enacted in this Parliament here. But it seems there are issues in the implementation, which was in fact highlighted by the Minister. So if you have implementation issues, and that's the reason why he's coming back to get those amended. And secondly, also, it seems also there are long-standing issue of a portion of society that is unable to afford legal assistance. And the third reason he gave, that is to also provide or to address the issue of professional misconduct and also legal education, etc. I think, if I remember right, we've dealt with this particular amendment before, but for some reasons it was withdrawn. So I think, he knows better why that was withdrawn in the first part. So I don't think we may need to take too long on this thing, because I know eventually it will be referred to the committee anyway, so to deal with it, so that they can come back to give us some of the issues that will be highlighted by the other stakeholders. On that note, I thank you.
Thank you, Honorable. In accordance with Order 67.1 of the Standing Orders, I will now open the floor for debate on the general merits and principle of the bill. Any honorable member who wishes to partake in the debate may do so now by show of constituency tag. I now give the floor to the member for Latrikunda Sabiji.
Thank you very much, Honorable Speaker. Honorable Attorney General, thank you for coming out with this amendment. And I also thank you. You are the friend of the National Assembly. Every day you are here. Huh? Yeah, exactly. So we thank you for that. Honorable Speaker, I think the first legal practitioners amendment bill was 2016. And 2016, I think I was a first-year law student at the University of the Gambia. There were some bullying aspects. I think it was during night time, myself and quite a lot of law students. We went to National Assembly members. I think I can remember we went to Honorable Samba Jallo's house at night to convince them not to accept the law at that time, because we, the students, felt threatened. To be honest with you, Honorable Speaker, every profession needs regulation, but students and potential lawyers should not also be bullied. And for me, the process was not consultative, because yesterday at the bar school page, I put this notice there for them to give us their input. All the students at the bar school said they were not aware of this. I also took a task an initiative upon myself and called many legal practitioners, private. They say they were not consultative. And in my opinion, Honorable Speaker, when we are preparing law, making law, it should be consultative, especially those people who are going to be affected by that law. You go to the University of the Gambia, you spend 4 years. You go to the bar school, you spend 1 year. You go from the bar school, you are called to the bar. Before you enroll, another 2 years. Okay, imagine I want to practice law. I am already 41 years old, and I need to take another 2 years to be 43, 1 year at the bar. This is too much. So I think this needs to be regulated. So I will wrap up my submission like this. We refer this to the subsidiary legislation. We deal with it, and then before we rush to amend a law here that is going to affect hundreds of potential lawyers in this country. But once again, Honorable Attorney General, thank you very much. You are indeed a friend to the National Assembly. Thank you very much.
Thank you very much, member for Latrikunda. I now give the floor to the member for Woolly East.
Okay. Thank you very much, Honorable Speaker. Honorable Speaker, I think these amendments that we want to make regarding the legal practitioners should be very much looked at. We all know we have a lot of problems when it comes to legal practice in the country. And one good thing I like about the amendment is the support legal services support to indigent persons. We know there are a lot of poor people in the country who cannot afford the services of a lawyer. So whatever arrangement that is there that helps poor people also to access justice, I think is a welcoming idea. Honorable Speaker, contrary to what my friend said there, we should regulate this, but in such a way that we have qualified people working in the system. Because if unqualified people participate in the system, there is a lot of chance that they will do injustice to a lot of people who are looking for justice. In some countries, for example, one will require to become an attorney. You will need to complete an LLB degree, 2 years of articles, pass the board exams, and be admitted as an attorney by the High Court. So you have to go through all that system. That is because it's not just making a table. It's a different matter. You are safeguarding the interests of people who are looking for justice. You don't want to send somebody to jail who is not supposed to go to jail. You don't want to keep somebody in jail for a number of years when the person should just be there for 6 months. So these are all things that we have to do. Also, Honorable Speaker, like it has been said here, you have some people working working as legal practitioners, but they themselves are committing misdemeanor, etc., against other people, but there is no way of disciplining them. For example, judges, lawyers would arrest certain people just because they have some argument with them. They would simply just order for their arrest, and then eventually they will release them without any charges. So some things should be done by legal practitioners. We must have that process going on. Also, Honorable Speaker, I think there is a difference between just lawyer and legal practitioner. There is a difference there. And I believe we should ensure that this deals with that also. What is the difference between these two groups? Also, like I said, we need lawyers, we need legal practitioners who, are groomed in public speaking. They've also dealt with social studies. And they understand science, because a lot of the cases that they are dealing with also require science and mathematics. So if it is just some of the lawyers or some of the legal practitioners I have seen, really, do not have any of these qualifications. So how do we create something that can suit us, but at the same time, it will not be an injustice on our people? On that note, I thank you, and I think everybody should just support this. And I support the idea of the member that we refer this to a committee to really look at it, to do justice to the bill. Thank you.
Thank you very much, Honorable Member for Uli East. I now recognize the member for Busumbala.
Thank you very much, Honorable Speaker. Honorable Speaker, the act before us is Legal Practitioners Act. The objective of the act itself is welcoming, as it seeks to address the problem of the society, like most indigent persons in the society cannot afford to pay the service of the lawyers. So if the bill is in force, that area will be addressed. And also the disciplinary committee, like the minister rightly stated, there is one in existence, but for some reason there are some constraints that make them inefficient to do their functions. And the bill also encourage the setting up of these misconduct, professional misconduct, committees that will deal with members of the bar or members of the legal practitioner fraternity that involve themselves into professional misconduct. We really have cases, few cases on this, and it's unfortunate those cases found their way at the criminal justice system. If this was in place, this bill was in place, such cases will be dealt with at the committee level, at the committee level. Like the member for Upper Salem rightly mentions, all laws and legislation should be put into consideration when they are coming into force. The consideration that need to be put is about the test of time. We want laws to take the test of time, So whenever we are making laws, let's put that into consideration, that we are not making laws for this few years, but we're making laws for a generation. I remember when the first Legal Practitioners Act was prepared, I was at the bar school, that's 2015-2016. Like he said, we also have that fear that, these bills are made to, delay us in our practice, in our practice. Or these bills, the objective of the bill is to make sure that, the senior members of the bar, keep enriching themselves, because the young ones will not be allowed or will be delayed in terms of setting up their chambers, in terms of, having that client's attention to, make some living for themselves. So those are the thinking, and those are definitely rational thinkings. So I will urge the minister that this bill needs such a thorough consultative procedures. The members of the bar or the students at the bar school should be consulted. General public need to be consulted, and also even the members themselves within the bar. Okay, and also if you look at there is a changes in this privilege, normally they will stay, the fresh graduate from the law school will stay for 1 year, but we have seen certain changes in the new bill, and also, but if I may, appeal to the Minister of Justice that there are certain fields that are very related to that of the profession, but yet still, if the students graduated from the law school were being asked to go for privilege, like the magistrates, a sitting magistrate who has been sitting for so long at the bench, but once he finished studying his BL, called to the bar, they will ask him or her to go for privilege. Certain consideration could be given to those people, and even the legislators. We are the lawmakers. We are virtually into this process. We are acquaintance with some of the laws that are made, because we definitely made the laws. So certain consideration should be given to members of the legislative houses, because we may not have that time to go for privileges, because we represent the people's interests here. So the minister should put that into consideration too. And also the police prosecutors. Like I have been prosecuting for 15 years before coming here. So I know of certain police prosecutors who have been prosecuting. They even met at the court with the minister himself, and they are graduates now. They were called to the bar. But yet still they cannot have that time to go and do their privileges. And that will be a bar for them to be enrolled at the, So certain things should be put into consideration, Honorable Minister. With these few remarks, I have also aligned myself with the submission of previous members for this thing to be referred to the not subsidiary legislation, but human rights and constitutional matters. Thank you.
Thank you very much, Honorable Member for Busumbala, for that contribution. Now, the member for Kantora and Majority Leader.
Thank you very much, Honorable Speaker, for giving me the floor. The task before us here is to give our blessing on the prayers advanced by the Honorable Minister and limit our intervention on the objects and reason for the said bill. Honorable Speaker, I want to commend the government through the Minister of Justice, Attorney General, for rising up to standard. There is an ongoing saying that the Gambianization of the judiciary, but of course, it is also important to bear it in mind to make sure we put people who are fit for purpose. And our quest for Gambianization should not also compromise for quality judgment, quality service delivery, well-experienced people to deliver justice. Remember, this bill is for the legal practitioners. These are people deciding on the fate of someone's life. To go to jail or to spend the rest of your life in prisons. So therefore, the amendments are apt and welcoming. You need every requirement, you need every knowledge. And I'm a fervent believer that wisdom doesn't come at younger age. Wisdom is attained at 40 above. So putting these caveats, making reference to thorough education and training, service to arrive there is very key. It only enriches our judicial system, more so to bestow trust and confidence in our judiciary. Currently, the government is really working to restore the loose trust. And these are some of the measures that we need to put in place to make sure every Gambian, regardless of financial status, have access to justice. Because it's a common adage that says that justice delayed, justice denied. We are not equal in status, but government is of the belief that what can states do to stand for you if you are not in position to save yourself? This is welcoming and it's the best practice elsewhere to make sure that your financial means should not deprive you or deny you of having, gaining justice. So, Honorable Minister, this is really good, and we don't really want to take much of your time on this. We have other many engagement coming after this bill. So I'm encouraging to have less intervention on this and also pass this thing. And of course, Honorable Speaker, the issue of the education. I believe that these are mechanisms that are put in place to attain the best people, in our legal system. And lastly is the issue of the practitioners themselves. They should not be seen as if they are above the law. They should be seen as they are also subjected to certain checks and balances. So having put in place this committee will serve as a watchdog, will serve as a deterrent, to abuse of office. So it's really progressive in nature. We passed this law not long, more than 3-4 years ago, and now it's before us here because of the current realities that we face in society, and we have to make laws to legislate them. So on that note, Honorable Speaker and Honorable Minister, I stand to give my full support and blessing. Automatically, whether you said or not, according to the standing orders, ABC will obviously refer this thing to relevant committee to make further scrutiny and then report back to plenary. On that note, thank you so much for your indulgence.
Thank you very much, Member for Kantora and Majority Leader. I now give the floor to the Member for Kiang East.
Thank you, Honorable Speaker, and good morning, honorable colleagues and Honorable Minister for Justice. The bill before us here is extremely important because the bill seeks to, or the amendments seek to address very important issues that are negatively affecting the legal system in the Gambia. The few speakers who just took the floor before me all seem to agree on certain things. Number one is that when laws are made, they are meant to last long. This particular legislation was legislated in 2016, and about it is 2023 now. We are thinking of amending the law again. And I want to agree with the previous speaker who said that when you make subsequent laws, it is absolutely important that we take into consideration durability. Durability is very, very important in law, because you cannot be making laws each time, and then after a few years you come back to seek amendment, although amendments are not bad. The judicial system in the Gambia here is fraught with a lot of problems, and sometimes people, sometimes it is ordinary people sometimes who actually suffer. There has been complaints here that there are a lot of cases lying in the courts that are not addressed. Well, that is true, but one of the problems also is access to lawyers to present people. Why? Because the cost of hiring lawyers is expensive. Only a few people can afford it. So people who cannot afford it may have problems, even if they are guilty in their cause, even if they are innocent in their causes. So since this one seeks to approve, since this bill or amendment bill seeks to address those issues, I think it's a welcoming amendment, and I don't think there is going to be any controversy. And Honorable Speaker, if it is not out of order, because since the debate has already started with it, I want to move a motion that we refer this to the ABC for subsequent committal to the relevant committees, which is possible. Thank you, Honorable Speaker.
Thank you very much, Honorable Member, and thank you, Honorable Members, who participated in this debate. I now invite the Attorney General and Minister for Justice to respond to issues raised and wind up the debate.
Thank you, Honorable Speaker. I couldn't agree more. Almost all the interventions were in favor or in support of the amendment. Actually, the mischief we are trying to resolve here is under the current Legal Practitioners Act. The Constitution of the General Legal Council is the Chief Justice himself chairs, and the Attorney General is the Deputy Chair, and you have the other members. So we receive a lot of complaints against legal practitioners that borders on professional misconduct. But due to the busy schedule of the Chief Justice and the Attorney General, it's very difficult for this committee to meet regularly. So we are now overtaken by the complaints that are coming. So That's one of the main reasons why we want to amend, so that we give the authority to the Chief Justice and the Attorney General to designate other people. Like I can designate a state counsel in my office to represent me, and the Chief Justice can designate a judge to represent him, so that as the complaints are received against lawyers, they are dealt with speedily, because these complaints are coming from the members of the public who go to secure the services of these legal practitioners. And for one reason or the other, they believe some of these legal practitioners were not acting professionally towards them. So they should have some form of redress. And because the General Legal Counsel is the body that issues the license to these practitioners to practice, and is the body that has the authority to withdraw their license and prevent them from practicing or impose any kind of discipline on them, this is the body that receives complaints against lawyers. So, but because the way the committee is set up at the moment, if you want the Chief Justice and the Attorney General, only the two of us, not to talk about other members, to be meeting regularly given our busy schedules, so it's difficult. So we have a lot of petitions and complaints against lawyers that are not addressed. So we say, no, let's just change the composition of the committee to reduce the representation, so that if the AG cannot be there, he can designate somebody, CJ can designate somebody, so that this committee can meet frequently to deal with these petitions and complaints and dispose them as they come. That's one of the main reasons. The other reason also is, like I mentioned when I was reading the issues, is access to the lawyers, like you all said. Legal service can sometimes be expensive, but it shouldn't be a deterrent. So through this amendment, we are now making it mandatory for every legal practitioner. When you come to renew your license annually, you should prove that you have carried out some pro bono service to the public. So you must show evidence that how many free service have you rendered. It will be a criteria now, annually. You should demonstrate that you have rendered some form of legal aid, if you want, to the members of the public. So if all the lawyers that are in the field are required to perform some form of free service to the public, cumulatively, the public will benefit in this. So these are some of the things that we're trying to bring on board. Latukunda Saviji and Honorable Member for Busumbala, your interventions are more or less very similar. I can understand. You are all budding lawyers, trying to become lawyers, not fully yet. It's normal, because the kind of controls that we are trying to put in place, those that are aspiring to become lawyers are not yet lawyers will feel unfairly treated, because we are making the conditions of becoming a lawyer a little bit difficult. That, like after law school, you need to do a year pupillage. After that, you need to do 3 years apprenticeship before you can open your own chamber. But let's face it, you take the profession of medicine. Lawyers don't just graduate from university and they start administering medicine or injecting people. They go through a process. They go through housemanship. They go through a lot of things before they are allowed to practice medicine on their own. So you may go to school, you may be the most brilliant graduate at the end, but the legal profession, by allowing you to open your own shop and start receiving clients, you have to go through a lot. Because those unsuspecting members of the public that are coming to solicit your service, some situations, they are entrusting their whole life to you. They are entrusting their whole life to you. So your academic degree alone doesn't make you qualify enough to deal with certain difficult cases in society. And your mistakes can cost somebody's business, entire investment, for example, if you advise him wrongly. Your mistake can land somebody in prison for the rest of his life. So to go through practical trainings before you are allowed to receive and deal with clients on your own, I think is necessary. Of course, young lawyers feel, why would you require me to go through apprenticeship for 3 years? Well, let's face it, what do we want? You've come from law school so you can go and open any shop and call yourself a lawyer and public will come to you just from law school? You don't have to go through under any senior so that you are shown how this job is done. Because all that we are trying to say is, from law school, it is too early for you to be allowed to operate independently. You have to operate under a senior lawyer for 3 years before you are allowed to open your own shop. And I think this is fair, because it is true that you will become and you will learn how the job is done, and then you then, when we release you to the rest of the public, we expect at least it's a bit safe. So we are only trying to protect the public. Of course, you are young, you want to start practice and start making the money quickly, but that's your interest now against the interest of the wider public. So that's what we are trying to balance here. We are not against people joining the profession. We just want to be careful that by the time we license you and ask you to go and operate, the members of the public that are coming to seek for your service will also be safe. You mentioned that certain professions should be given credit for the kind of job that they do. And by giving them credit, that means the apprenticeship should be waived. I think the job you are doing in the National Assembly here is completely different from the job you're going to do as a private legal practitioner or a legal practitioner in any other environment. So you know what I'm talking about. You have to argue very, very hard to be able to convince us that by having served as a National Assembly member, we should credit you for that and waive the practicals for you. It's difficult. I know you talked about police prosecutors, you talked about magistrates, but again, we're still looking at public interest here. You may have served as a magistrate, as a lay magistrate before you are trained as a lawyer. So from being a lay magistrate, you went to law school, you got a law degree, you went to university, you got a law degree, you go to law school, you got your LBL. But should we say, okay, you have been a magistrate, so therefore here is the license, go and practice. The thing is, the General Legal Council that issues you this license to go and practice wants to satisfy itself that you are fit and proper to practice. And while you were doing that job that you were doing as a police prosecutor or as a magistrate, you were not under the watch of the General Legal Council. And the General Legal Council want a certification that you are fit and proper before you are issued the license to go and practice. And we are only doing it to protect the public. It has nothing to be against those who want to become lawyers. We just want to be sure by the time you are certificated, the public is prevented or protected somehow. Well, it can go to the committee. Of course, that is part of your standing orders, is your procedures, and once we submit a bill here, we don't control the journey of the bill. But I want to implore on the Assembly if we can expedite it a little bit. I don't know how best this can be done, because like I said, we have a lot of backlog of disciplinary cases against lawyers. A backlog of disciplinary cases against lawyers, and this amendment, if it is expedited, the better for us, so that these committees can sit and start looking into those complaints. Where lawyers are found wanting, they will be disciplined accordingly. If it means their license be withdrawn, we have started that already. Some lawyers' licenses are being withdrawn, and if you are withdrawn, you don't practice law. You know, if it is that serious. Those that, for example, is money related, you retain the client's money unfairly, we order you to pay back the money and return it, and those kind of things. So we have a lot of complaints that we want to deal with. But as it is now, it has to take the CJ and the AG and other members of the committee to sit regularly to look into this. And if, because of our schedule, like I said earlier, it's finding us very difficult to catch up with the number of complaints that are coming. So consultation is true. Like some people are saying, law students claim they are not consulted. But I know this bill, I am told it was subject to some form of consultation and even a validation workshop. So, and currently it has been put on the bar page, and they are discussing it, lawyers are discussing it. So if they have concerns, I'm sure you can open a limited consultation, they can let you know what their concerns are. But nobody wants to be regulated very hard too, so we need to be mindful of that. I belong to this profession, but I have no problem with the profession being properly regulated in the interest of the public. Thank you. Thank you very much.
Thank you, Honorable Attorney General and Minister for Justice.
Yes, Speaker.
Yes.
Yes, thank you. I think the Minister just said something that maybe...
Yes,
I was just trying to... because he was saying that probably even though we can refer to our committee, which is the norm here anyway, but asking for us to expedite. But just to remind him that also within our standing order, also clause 77, we have something we call certificate of urgency. If it is needed in the public interest, you can get the president to sign for on the certificate of urgency, and then you can talk to the office of the clerk for that to happen. Yeah. Thank you.
Honorable Member, and that means it will be withdrawn, and then they bring it back, or we can continue.
Yes.
Member for Upper Salem?
Yes. Yes, he can bring it anytime, but there's a procedure behind the scenes. We means if we accept the certificate of urgency through a motion, then he can immediately move a motion to withdraw this bill, and then he present the order as certificate of urgency.
Exactly.
Yeah.
That's my point. Yes.
Yes.
Member for Fonye Councillor.
Yes, I want to yes, I want some clarity to it as what the Honourable Minister has said, because I'm overtaken by some of the pertinent issues that he has mentioned, and I think with those clarity we could make progress if it's so to my side. That is one. How long do the two of you sit on these petitions, and so far how many cases that are in your table? And the other thing also, as per what the Honourable Member of Bosombala has said, where you have police prosecutors that are in the job, now university, they go to the privilege and be waived. I don't know whether, if possible, if you look at the School of Nursing, where you do SEN, CHN, you are waived. Would it also be possible at that cadre for some regulations to be made in conformity with the law to see if it is possible? I want you to also help in that. And the other thing also is about the criteria of 3 years. The criteria of 3 years. Honourable Minister.
Mr. Speaker, the point of order, Honourable.
Hello?
Yes, I'm in floor. Can you please help us?
Please, Honourable Member.
Okay, thank you.
Can I observe? Don't use your mics. There is a point of order from the member for Woolly East.
Now, just the debate is closed, so are we opening it again?
No, please. No, he's... Member for Kantora, I'll come to you. You want to seek clarity?
What I'm saying, according to Standing Order 76, Standing Order 76, withdrawal of a bill, the person in charge of the bill may make a motion without with notice to withdraw a bill at any stage before it has been read to third time. So which means that the Honourable Minister can really withdraw this thing now and then reintroduce again under certificate of urgency for us to sit one day and pass it, if it's that urgent.
Member for Brikama North and Minority Leader.
We understand the concern of the Honourable Minister. Let's allow the bill to be referred to the committee, and we urge the committee to act on the bill urgently. Rather than to act on it one day, I think that will be dangerous. Please.
Member for Kantora.
What I'm saying, I'm not trying to against procedural matters here. The advance reason given that is so urgent, if truly, because we've passed this bill in 2019, I think so, 2016. I know. Then if the bill now is now not really standing the test of time, and is that urgent to regulate the concern of citizens, and he deemed it fit, I'm saying that the law provides, standing order provides us, he could withdraw it at any stage if it hasn't reached the third stage of reading and reintroduced. Now it's left to him. He's the constituent of the bill to do so.
Member for Sanementreng.
Thank you very much, Honorable Speaker. Honorable Minister, what's the urgency in this bill that it cannot wait for the committee stage to be finalized, and then after we can pass it to the I mean the urgency, the most urgency in the bill, that it cannot wait for the committee stage to finalize with it and then move on to the plenary for final doing.
Member for Attorney General, please take note. Member for Brikama North.
I understand the procedural aspect of it. What I'm saying, the concern of the Honorable Attorney General is well noted. If we want to treat this bill right at the moment under certificate of urgency, that is going to compel us to treat it one day. Well, we are hearing the concern of lawyers. I'm coming. When that happens, there will be no broad consultation. Since others are feeling that they are not consulted, let's create that room for consultation to go ahead, of course. And we urge the committee to make sure they act on it urgently. This is what I'm saying. But under certificate of urgency, we'll be compelled to treat it one day. And those who fell excluded will continue to be excluded.
Opasalo. Yes, thank you, Honorable Speaker. I think we are missing the point here. I was just trying to remind the Minister that there is another avenue. If you want, that's all. We are not saying that let him bring it on the study. No, we are not saying that. If he prefers to do that, when he comes, we will debate and vote. No, wait. Our procedure is very clear. We are not asking to do that. I'm just reminding him that there is a procedure that is available that he can use to do that. So if he decides to come on the second urgency, it's up to us to agree or not to agree. So we are just reminding him that nothing else.
Nominated member Kebalang Fofana.
Thank you, Honorable Speaker. I think Honorable Mbo just spoke my mind. We are opening up a new debate, which is not part of it. We've made a decision that the bill is going to be committed to committee level. So let's move on with that. If the Honorable Minister so decides to bring the certificate of urgency, at that point we can start the debate on that particular motion. But as of now, let us all decide that we are sending it to the committee level. And the committee also, it will be important at this point for us to make a timeline. The Honorable Minister have really expressed his concerns. Can we work on a timeline for that? You know, I think if that is possible, that will definitely help. Thank you.
Procedural matter, please.
Member for Busumbala.
Mine will be just, clarification from the minister. We understand this bill just came into existence 2016. Prior to that, are the legal practitioners doing this privilege? I understand some from the, law school get direct enrollment. So I put the argument on behalf of the police prosecutors and the magistrates because they have been in the system within the legal fraternity. Thank you.
Honorable members, Honorable Member for Fatou. Yeah, Honorable members, I think what is clear is that the Honorable Member for Fatou, Honorable Member for Fatou, you made some submission here. The Honorable Member for Falou's proposal was a suggestion, but that's not in any way coming from the Attorney General and Minister of Justice, who is the mover of the motion. And the stage at which we are today is on the third reading and debate on the general merits of the bill, which has been completed. Yes, for the second reading. And the debate on the general merit of the bill has just been concluded. And then once we put the question in accordance with Order 68, is for the bill to be committed to the ABC automatically. And that's where we are. Honorable Minister, there were some clarifications sought by members. Please proceed and respond.
I start with Councillor. It's linked to Busumbala still. You are still emphasizing on whether the need for a waiver for certain professions like police prosecution. I am one member of the council, but of course the justice policy is under my purview. What has been decided is, if you have been working in government, like police, prosecutors, drug law enforcement officials, armed forces officials are also studying law, immigration officials are studying law. You can do your pupillage at the state law office. And because they come to do pupillage at our office, I can assure you, we do see a lot of gaps that needs to be filled. So waiving it will put the public at risk. We need to understand this might not apply generally to everybody, but you rather apply it, the minority that think they are fit and proper should go through it in order to avoid us releasing the majority on the public that are not fit and proper. I don't know whether you're following. And that brings me to what Busumbala tried to argue on your second bite of the cherry. That affects me. Let me put myself there. We were the first batch of law students. At that time, the Legal Practitioners Act that was in place don't require pupillage. So from law school, we continued. We just melted into the profession. But I'll tell you, for instance, in our batch, I don't think we were even more than 20. We are now mass producing. The intake at the law school now, per annum, is in the ranges of 90 and going up per annum. So we are graduating almost 90 to 100 students a year. So we are at the stage of mass production, and I think that is the reason why a bill was tabled before this National Assembly to look at it. And also the feedbacks that we are getting from the field, what lawyers are doing, the kind of practice, the feedback that we are seeing. The General Legal Council, and I think even the Bar Association is in agreement, because they are members of the General Legal Council, that we need to tighten up regulations. So for me, to argue to say that, let's say 10 years ago, there was nothing like this, why are you bringing it now? Because the need is felt now that it should be done. So to me, that's just the answer. It is felt that the regulations need to be tightened up. And I don't think there is anything wrong. We are doing that every day. There are sectors that we are tightening regulations all the time. Now that society feels that the risk is too high, more lawyers are graduating, and we're seeing the negative effect of lack of giving the comprehensive kind of training and practical trainings to the lawyers. The effect is coming every day. You can just simply check that by the volume of competitions and complaints we are receiving. 10 years ago, 15 years ago, you might not have been receiving that number of petitions. So there are so many justifications why we need to even tighten further the regulation. Unfortunately, you should have come 10 years earlier or 15 years earlier. So you are just caught up, I'm afraid. So sometimes we pay a price for being a bit late. I mean, I just put it that way. But yes, there may not have been regulation 10, 15 years ago, but I don't think that could be an argument to say we should not regulate now. So we are regulating now because we feel there is a need to regulate now. So Madam asked about what is so urgent. Nothing extraordinary other than what I said. Even if it is going to go through the committee, my only appeal is if it can be a bit expedited. Like I said, day in, day out, we are receiving a lot of petitions. Also, access to justice continue to be a big problem for poor people. This amendment will open all those windows. So we want to make it available to the public as soon as possible. But we have a lot of petitions lying that needs to be litigated. Similar to what we are complaining about backlog of cases in the courts. So basically, this amendment will help to release and free up a lot of backlog of petitions we are in possession now against legal practitioners.
Honorable members, it has been moved and seconded that the bill entitled Legal Practitioners Amendment Bill 2023 be read a second time. Those in favor, please say aye. Those not in favor, please say no. The ayes have it. Clerk.
Honorable Speaker, I hope the minister defended the Constitution, the draft Constitution this way. It will be fine. Thank you.
Second reading, Legal Practitioners Amendment Bill 2023.
Honorable members, in accordance with Order 68.1 of the Standing Orders, the bill is hereby referred to the Assembly Business Committee for committal to either a committee or committee of the whole Assembly. Thank you. Clerk, we may proceed.
Bill, with reference to Standing Order 66, second reading of the Intellectual Property Bill 2023 by the Honorable Attorney General and Minister for Justice.
Honorable members, you will recall that the first reading of the Intellectual Property Bill 2023 was done on Monday, 5th June 2023, and today is appointed for the second reading in accordance with Standing Order 66-2. Therefore, pursuant to Order 68 of the Standing Orders, I now invite the Honorable Attorney General and Minister for Justice to move a motion for the second reading of the bill entitled Intellectual Property Bill 2023. Honorable Minister.
Thank you, Honorable Speaker. Honorable Speaker, the bill entitled Intellectual Property Bill 2023 having been read the first time, I hereby move that the said bill be read the second time. The purpose of the bill is to give effect to Intellectual Property Rights Administration, which is currently fragmented and administered by two distinct institutions in the Gambia. Industrial property rights are administered by the Ministry of Justice, while copyright and related rights are administered by the National Center for Arts and Culture under the Ministry of Tourism and Culture. This segregation of administration and mandate has generally affected the development and efficient administration of intellectual property rights in the Gambia. The enactment of the Intellectual Property Bill 2023 will therefore streamline the administration of intellectual property rights and make it a one-stop shop in line with the principle of ease of doing business and international best practices. Furthermore, the enactment will also give an opportunity to new intellectual property regimes which are beneficial to national and international intellectual property rights holders to be incorporated in the Act. In addition, the Gambia being a member state of the World Intellectual Property Organization, WIPO, the African Regional Intellectual Property Organization, ARIPO, and the trade-related aspects of intellectual property rights, TRIPS of the World Trade Organization, has a legal obligation to ensure that intellectual property rights are effectively administered in its jurisdiction. So therefore, as part of the process of defining the practical application of these conventions and agreements, this bill has made provisions to ensure adequate provisions to address all issues of intellectual property right. I so move.
Any seconder? Member for Fatou.
Thank you very much, Honorable Speaker. I rise to second the motion and also to speak on it equally. You know, we have this bill that intends to streamline one of the most important institutions in the country. Now, first, as members of society, it's very clear that once we do something that is not in line with the morality of society, we get punished. But equally also, if you do something which is innovative, which is really very progressive, we get rewarded. And that's the reason why, for the most part, you have inventions that are actually protected by people that actually make them. Now, if you look at what is happening right now, as alluded by the minister, it seems there are two offices that are actually overseeing such. If you look at the Ministry of Tourism, that is dealing with copyright and other related matters, and then look at the Ministry of Justice, that is looking at industrial property. So you're going to see that it's kind of like one is going south, the other is going north. So having one office, that's going to bring everything together to streamline. Actually, it makes it really much easier for us, and it's going to make the administration much simpler. And I think this bill is really timely, and it's also really very good for us to have such in the country. Now, if you look at the bill also, by looking at the on the patent during employment relations, which is really very good. So you are not only giving credit only the employer, but also the employee himself. Once you are in active employment, you also have some kind of economic benefits by being the inventor. So which I think is really very good because you can be employed by somebody, and due to your innovativeness, then you are able to create, which is really going to be good for society and also good for the company that you work for. But at the same time, you will also be equally rewarded while you are there or when you leave. So this is really a step in the right direction. Now, if you look at the only issue that I have not seen covered, is the issue of artificial intelligence. Scientifically now, because right now actually I'm reviewing almost 80 workshops for the United Nations dealing with artificial intelligence, and this issue keeps coming up. How do you patent or how do you provide copyright on products that are created through artificial intelligence? This is not human intervention. You're using computers, you are using applications to create something. Now, who actually owns it? So I've not seen this bill actually cover that particular area, even though I've seen it attempt to do so by way of computer systems and stuff like that, but it has not actually dealt with that issue. So maybe I want the minister to help me understand how do they intend to treat such, because it's a very big issue right now worldwide. So I think it's equally important now to be very innovative in case things like that actually happen, because it's already in use in many parts of the world, even in this country here. So what happens if somebody uses AI and creates a product? Who actually owns it? What kind of right can you put on it? So I think the minister needs to help us to answer that question. Now, the other one I have for the minister also, which I think is equally important, because again, we are part of the African Union, but I just realized, maybe the minister can help, that the statute of the Pan-African Intellectual Property Organization, that's the PIPO, I've just seen that Gambia actually did not sign or did not actually ratify. And, as a member of the African Union, and I think these are some of the things that we really need to be looking at, at the initial stage, get these things, sign off, and then bring such a bill. So on that note, I want to thank you.
Thank you, Honourable Member. In accordance with Order 67.1 of the standing orders, I will now open the floor for debate on the general merits and principle of the bill. Any honorable member who wishes to partake in the debate may do so now by show of constituency tab. Member for Busumbala.
Thank you very much, Honorable Speaker. Thank you so much, Honorable Minister, for presenting this intellectual property bill before the Assembly. Honorable Speaker, the objective of this bill is to discourage infringement. As we know, there are so many creations made by people, individuals in this country, but because of the bill was not enforced, so there are so many infringements upon to their creations. And like the minister stated, this particular bill is been administered in two different departments. That's Minister of Justice and that of the Arts and Culture. So you will see to read that the prudence of the individual who seek this industry as their, who benefited these products have been suffering in many times. Some get discouraged at times because they don't have a one step window to go and do all the registration required for them to establish, for them to protect their products. So if this bill is coming into force, it is going to redress that. And as such, people will know whether they should go to the Minister of Justice for all their registration to protect their patents and copyrights, or to that of the arts and culture. So the bill comes at a time when Gambia, in essence, is into all these organizations, like the World Trade Organization, the African ARIPO, African Regional Intellectual Property Organizations, and even, WIPO. So I was privileged to attend a workshop in Zimbabwe on this ARIPO conference. So one beautiful thing of this bill, it is definitely going to put Gambia into that stage where we will become primary beneficiary to so many benefits that these organizations are doing in related to this bill. On that note, Honorable Speaker, I definitely in support of this bill. Thank you.
Thank you, Honorable Member. I now invite the member for Woolly East.
Thank you very much, Honorable Speaker. I think we will have to thank the Minister for bringing this. I think it was here, and then for some reason it has been taken back. Honorable Speaker, I think if the standardization, for example, is quite apt, and if we have not ratified the ARIPO or whatever convention relating to this, we should urge the Minister also to bring that so that we'll be able to move in tandem. My major concern, Honorable, I think this bill will address those issues. Because really, if you look at it, our people are inventing every day. They are writing, they are inventing, they are producing. and they have a right to patent. But we all know that is a problem. Even if there is a law on this, how many people know about that? If you take an example of, I give an example of somebody in Willi Kolikunda, and he's producing beautiful Busungo. Busungo. How many of you know Busungo? Only those from URR maybe will know Busungo. If you do fishing in a pond, that's a fishing equipment. It's like this, and then you put it exactly, and then you put your hand in the hole, and then you catch the fish, and then that's a very good fishing equipment. And then you know what? You know, a Chinese man came to the Gambia and saw that, and took the idea and went and produced it, but make it into iron and make it stronger. And he's bringing it back and selling it back to the same people. So he's killing our traditional one and bringing a modern one. But then that person who originally made the Busungo did not have patent, has no way of registering this, does not know anything about that, but this person just came and steal the idea. And I'm sure he must have patent in his own country. So how do we, I think this one will definitely address that type of thing. You also have an example of a lady, they said it was in Kenya, I read that. And then this European man came to live with these local people in the rural areas. And then he got sick there. And when he got sick there, started vomiting and all these things, and then the lady saw, an old lady in the house saw him vomiting and all these things, fever and all that, and then went to the bush just at the backyard and bring this herb and gave it to this guy. And then in the morning, he gets well. He got well. But when he was returning to Europe, he went back to the backyard and got the leaves and all that. And then when they do their checking and they see what chemical compounds are in that, until this, that is really the cure of this, and they discover that, then it's patented in that person's name. He came back to Kenya and did some payment to the lady, but did not explain to the lady that your knowledge, you know, is what I use. Now I am using that, I'm benefiting from that. He did not say that. So the lady did not get any patent. So every day our people are inventing, but they are not having patents. Honorable Speaker, our artists, we have a lot of artists here. Some are in arts, producing music equipment. Some are having sons, etc., etc. Some are in medicine, you know, like I said. Some are writers, you know, and then we need a standard institution that will actually do this, because it's not being done properly. So I believe this bill will do justice to all of them. Copyright, relating to our writers. But we also have people who are plagiarizing every day. If I listen to the rappers, some of the rappers, the music that they play is not their music. Where did they get that music? But then they take the rhythm, and then they just add Mandinka words there or Wolof words there and mix it, and then they have they make it their own. Songs. I say many songs. If you hear the beating, you know that they don't have the band to do that beating, but then they mix it. Huh? Whether that is acceptable. Is that acceptable? That's what they are doing. So that's something that maybe this will address. But I was thinking also that you may have 2 or 3 people producing the same thing, and they all want to register it at the same time. How do you deal with that? Do you join them? Do you know? I've not done any reading, so I don't know. But I believe those issues will come. Somebody say, I'm the first to produce this. Other one say, no, I'm the first to produce this. So if that happens, what do we do? Yes. Okay. I think, yes. I was just thinking of another equipment, the hive, the local hive, which is preserving they call it kumbo. It's very good. You know, it's like this, like a bowl, but you made it out of grass, and then the bees will, you know, produce the honey in that hive, and that's a local one. But all those people are not giving any patent. They don't know. Some are producing guns, in fact, in my constituency, but they are not patented. So I think this is quite apt. And what really makes me happy about it is that an institution now will be solely responsible for this area, instead of different institutions that are not really doing justice to the thing. We thank you for the bill. Thank you.
Member for Olyundu. I give the floor to the member for Olyundu.
Thank you, Honorable Speaker. I just want to be brief as well. First of all, I want to thank the Minister for this bill. Under objects and reasons, I think Gambia is moving forward in terms of, putting the right frameworks in place for us to progress. For the fact that we registered to be a member of the WIPO and then the ARIPO, and also the TRIPS. This shows that, we are prepared to protect the right of our citizens, especially in the music industry, the artistic, and all other sectors. So I think it's important, like the member for Willie is said, I was going to say the same thing. In the music industry, you hear a Gambian musician with, most of them have talent. They can compose very good music. At the end of the day, it stops there. But maybe in the long run, when they register their songs with the intellectual property, it will be protected for them moving forward. But I just wanted to ask this question because I'm reading on the, I don't know, I have not seen it anywhere. Like, for example, when there is an infringement, should it be the person who is infringed to report it to the body that is administering the intellectual property, or they should also be monitoring what happens within the society to be able to know exactly what happened and where it happens? I mean, they took it from there. And that is a question I wanted to ask from the intellectual property bill. Thank you, Honorable Speaker.
Thank you very much. I now give the floor to the member for Fonye Councillor.
Thank you very much, Honorable Speaker. I thank the Minister bringing this bill. I have some maybe questions and also some progressions that I think it will definitely help. As alluded before, it was in two in one, but now it's going to concentrate on the one arts and culture. I think it's progressive, and looking at the back end objectives, you realize that if the Gambia has also been members of various intellectual properties organizations. I don't know whether all these intellectual properties, Minister, you can help us, are all intact and we are still full-fledged members into those organizations. The other thing also, looking at the other end where you have border measures and also applications for suspensions of clients, I think it's in line. I believe this will also help a lot for our artists in areas of various art fields, that apprehensions and measures will also be put in place. The other thing that I've also went through this bill that I haven't seen is good. We come with bills of this matter, of this, progressive as cities. But trying to work on a massive sensitization of these artists in different capacities, whether the arts and culture will also be working in this, because this will be a new bill where most of them, educated or uneducated, will also be part and parcel in this. What is there if this particular bill is passed for a comprehensive approach for various artists based on different performance of the artist field. And the other last thing is arts and culture. Are they of capacity currently if this bill is passed? Where you talk of the machinery in terms of technological aspects now, whether a music has been sent, they transcribe, a lot of issues that we know. You talk of Interpol today in the Gambia police, where an audio is set linking with outside source. Do we think at your level, arts and culture are in position, if this particular bill is passed, what is the state of the infrastructural development so far connection to this bill is concerned? Thank you very much.
Thank you. Thank you very much, Honorable Member. I now invite the Honorable Attorney General and Minister for Justice to respond to issues raised and wind up the debate. Honorable Attorney General.
Thank you, honorable members. Honorable member for Upper Salom, AI, is an evolving new area. Now, if you look at the issue of creatorship and inventorship, the laws are such that human intervention is contemplated. So the evolution of AI technology nowadays is relatively new and countries are struggling to regulate it. So it is not adequately covered here. Of course, to some extent, you can look at it from the perspective of the person that controls the AI program and directs any intervention or a creation of something. But to answer your question directly, we are not regulating it at the moment because it's an evolution that is going on. If you are following international, I'm sure you do. You hear several countries are meeting and international meetings are being organized to see how do we regulate AI. So because it's an evolving area, we are waiting to see how it goes. But at the moment, it can fall under the person that is in control. It's just like a computer-aided design, for example. So the person in control of the technology that led to the creation of a particular thing or an invention of something, probably at the moment will find a way of arguing that it's my creation or it's my invention until at such time that when we are able to properly regulate it. And thank you for your support for the bill. You raised another issue that the Pan-African Intellectual Property Gambia did not sign. That document is still under negotiation. And because there is already ARIPO, African Intellectual Property Organization, which is predominantly English-speaking countries. I think the French do have their own. So the Pan-African one that is coming is being debated, is negotiated. We are participating in the negotiations. So let me not say much, but we're working on it. If we don't know eventually if we will come up, whether we want to be a party, but we are participating in the development and the negotiation. We attended the last meeting held on it. Honorable member for Woodley East, ratification, yes, there are a lot of instruments that we have not ratified yet, so we are compiling them and they are on their way here for ratification. You raised a concern about if two or more than one person jointly produce something who has priority of right to register. But I respect you because you acknowledge you have not read yet. So when you get into the bill, you will see it is covered under Section 15 right to patent or naming of inventor. And he said the right of a patent shall belong to the inventor. But however, 2 said, if 2 or more persons have jointly made an invention, the right to the patent shall belong to them jointly. That is the first option. The second option is if 2 or more persons have made the same invention independently of each other, the person whose application has the earliest filing date. So now it's the who first applied to have a register. All right? As long as, so it becomes the first in time. So if you first apply to register it as your own, so long as your application is pending and has not been withdrawn or discontinued or abandoned, is being processed, you have a priority of right over that invention. But if you abandon it, you withdraw it, as you withdraw, the other person puts it in, then that person's application will be considered over yours. Yeah, so, but the details are covered. Once you start going through the bill, those fears are covered. Oliundum, the concern about the enforcement, because it's more on enforcement, who reports, what's the monitoring. This bill is innovative because it's introducing an intellectual property tribunal. So now once the tribunal is established, you know, these are rights. So once the right is granted, you register something and the right is granted to you, you are the right holder. So you can choose to exercise your right or waive it. So if somebody infringes on your right, technically it's left to you. If you feel aggrieved and you want to take up the matter, it's you, the right holder, that decides. Nobody will decide for you. You can choose to forgive, you can choose to negotiate and settle, but you can choose to go to the tribunal. Whichever way you want to force your right, the most important thing, the law gives you the rights and protects that rights for you. But once it is infringed, now you, the right holder, decides what you do with the infringement of the right that is guaranteed by law. Councillor, yes, we are still members of all these listed international organizations. We are not just members, but active members, per se. Thank you. Thank you very much for your support. Thank you very much. Oh, yeah. Once this bill is passed, that function of NCAC is now going to be transferred to Intellectual Property Office as a one-stop shop now. Yes.
Thank you very much, Honorable Attorney General. Honorable members, it has been moved and seconded that the bill entitled Intellectual Property Bill 2023 be read a second time. Those in favor, please say aye. Those not in favor, please say no. The ayes have it. Clerk.
Bill Intellectual Property Bill 2023 is hereby deemed to have been read a second time.
Honorable members, in accordance with Order 68(1) of the Standing Orders, the bill is hereby referred to the Assembly Business Committee for committal to either a committee or committee of the whole Assembly. Thank you. Clerk, we may proceed.
Order 72, continuation of the consideration stage of the Anti-Corruption Bill 2019 by the Honorable Attorney General and Minister for Justice.
Honorable members will recall that the consideration stage of the Anti-Corruption Bill 2019 began in earnest during the previous session. However, the Assembly could not complete the process and stopped at clause 9 of the bill on Tuesday, 28 March 2023, to be precise. We will therefore continue today from where we stopped. during the previous session. However, during the consideration stage, members shall have the opportunity to give detailed consideration and scrutiny to every clause and schedule in the bill. This stage also provides the first opportunity for amendments to the bill to be debated and voted on. I will now therefore resolve the Assembly into committee of the whole Assembly to give consideration to the bill, that is the Anti-Corruption Bill 2019. The Assembly now resolves into the committee of the whole House.
2C bi dañ ko delete ka.
The Assembly The Assembly will now go into the Committee of the Whole Assembly to consider the Anti-Corruption Bill 2019 clause by clause. We will also be guided by the committee's report on the bill and clause 72 of the standing orders during the consideration stage. Clerk.
Clause 10, expenditure of the Commission.
Clause 10, expenditure of the Commission. It is proposed that clause 10, expenditure of the Commission, stands part of the bill. Yes.
What the committee recommended was to make the introductory statement where it says the Commission may apply its funds. We make that as 1, followed by A, B, C, D, and then we made another subclause 2, and make it the emoluments, allowances, and the benefits of the Commission shall be determined by the Minister in consultation with the Public Service Commission. So we have the clause 1 and 2. It's on page 4 of the report, of the FPAC report, page 4. Sorry, 3 continue in 4. 3 and 4. 3. Yeah.
3 to 4.
Yeah.
Their proposal is to make an introductory statement.
We gave you the correct one.
Put off your mic. It's bottom of page 3, the report. Please, member for Upper Salon. Please. Yeah.
Yes, on that one, the committee made a recommendation that if you look at the first part, it says the Commission may apply its funds. We make that subclause 1, and then followed by 1, A, B, C, D, just as indicated in the bill. Then we have subclause 2.
Yeah, honorable members for Olyundum and Jarais, what's the problem? If they don't have copies of the, can you help them, table office? Table office, can you provide the copies to some members who may one reason or the other lost their
I have 2022 rather.
I think honorable members, member for Janjambure, you also want a copy?
Yes, please.
This one is not correct. No, this is also not correct. one. Otherwise, it will not be synced. You will find the page and it will be different.
I think maybe we stand down for 10-15 minutes so that we'll help some of the members to... Table clerk, the assembly... No, it's not the assembly, the committee. Honorable members, at this stage, the committee stage is suspended for 10 minutes.
Increasingly popular mechanism for poverty alleviation, especially for developing countries around the world. This microfinance service adheres to the principles of Islam as a form of social responsibility. Yona Islamic Microfinance is the Islamic microfinance of choice in the Gambia, trustworthy and reliable. At Yona Islamic Microfinance, we provide savings products, current accounts, financing products in conformity with Islam. In addition, Yona Islamic Microfinance also offers local and international remittances, takaful fund, management of zakat, management of awqaf, trading and investment, and building of strategic partnerships to bring financial services to the doorstep of the poor with donor projects, madrasas, youth organizations, women groups, and farmer organizations. Make a choice with Yona Islamic Microfinance today. For more information on Yona Islamic Microfinance, call 377-2151 or 9832-151 or visit Yona head office at Tipa Garage, Bakote, or visit any Yona branch located countrywide near you.
Agada. Albaka.
Mbaka important.
Yo, nga transfer la sto.
Ya transfer la sto.
Ha, code nyingi.
Okay. Still ID soto.
Sa soto. Sorry. Agada.
Bijandro.
Albaka.
Mbaka.
Bara alla service ko tariaka.
Mbare.
Mo ki janna nun kunu bara tariaka.
Jannom Yona Forest de Bureau. Gambia tonkon na no mbali ya bere. Birim ko na fokato.
Barisi kodo kino kato ni fo bolong labe.
56 branches mola soto Gambia jam.
Ha?
Gambia kono ani Gambia bantala bankol. Nko kodo kiya bere. Kodo sifa fo falindiro fo nyaadi la
memmen na kodi to poto nim kodi maro dan number 1 di nyonta andum fana nata anoda enterprise sotale wala nyindi ko domorol fana ko fana be firale de dadi ma ni domorol ni fana be teat Gambia dawda yalo ngam fa kendol sotale di
wo moyo diat
apelen da
barka ni na lafta nyelen kendol e bina
yalo bu kanyi la ko la barka ba
yalo ndel ciosano
barka
Islamic microfinance is becoming an increasingly popular mechanism for poverty